Before anything else, if you are in immediate danger, call 911. If you need support or want to talk through your options, the National Domestic Violence Hotline is available at 1-800-799-7233 anytime, day or night. What follows is general information about a California court form, not a substitute for that kind of help. Form CH-100 asks a California court for protection from someone who is not a spouse, partner, or close relative. Here is what counts as harassment, how fees work, and how CH-100 differs from a domestic violence restraining order. What is Form CH-100? Form CH-100 asks a court to protect you from someone who is harassing you, threatening you, or has been violent toward you when that person is not a spouse, partner, or close relative. It identifies who needs protection, who you are asking the court to restrain, how you know that person, and what happened. Filing fees can apply to a CH-100 request, covered later in this guide, though a fee waiver is available when the harassment involved violence or threats. What counts as harassment? For a civil harassment restraining order, harassment generally means one of two things: violence or a credible threat of violence directed at you, a knowing and willful course of conduct, meaning a pattern of behavior over time that seriously alarmed, annoyed, or harassed you, served no legitimate purpose, and caused you substantial emotional distress. A single angry conversation or an isolated disagreement usually does not meet this standard on its own. Courts generally look for either an act or threat of violence or a repeated pattern of conduct, such as unwanted contact, following, surveillance, or threats over time. Civil harassment versus domestic violence. This is the most important distinction to get right before you file, because it determines which form you'll typically use. Key takeaway: whether you file CH-100 or DV-100 depends on your relationship with the other person, not on how serious the harassment or abuse is. If your relationship qualifies for a domestic violence restraining order, you generally cannot use CH-100 instead. Who can file CH-100? You can file CH-100 if you have experienced harassment, as described above, from someone who does not fit the close relationship categories that qualify for a domestic violence restraining order. In some cases, you can also ask the court to include other people in your household, such as family members who live with you, as protected persons in the same request. A business can also file a CH-100 request in some circumstances, such as when an employee or customer has harassed or threatened staff, though workplace violence situations sometimes fall under a related separate form instead. If your situation involves a workplace, a court self-help center can help you confirm which form applies before you file. Describing the harassment. CH-100 asks you to describe what happened in detail, including specific incidents, dates, and, where relevant, whether the person used or threatened violence. As with other restraining order requests, judges generally give more weight to specific, detailed accounts, including dates, locations, what was said or done, and whether anyone else witnessed the incidents, than to general statements. Key takeaway: if you are checking the boxes for violence, stalking, or threats of violence on CH-100, described later on the form, those incidents are generally described as specifically as possible. These are the same boxes that waive your filing fee. Orders you can request. CH-100 lets you ask the court to order the other person not to harass, threaten, stalk, attack, strike, molest, destroy the property of, or disturb the peace of you and anyone else the order protects. Depending on your situation, you can also request stay-away orders, keeping the person a set distance from you, your home, and your workplace. No contact orders, prohibiting phone calls, texts, email, social media contact, or contact through a third party. Orders addressing specific behavior described in your request, such as surveillance or unwanted deliveries. As with a domestic violence case, every protection that applies to the situation can be requested, since a judge generally cannot grant more than what you requested. Filing fees and fee waivers. Standard civil filing fees generally apply to a CH-100 request. However, there is no fee if the person you want restrained has used violence against you, has stalked you, or has threatened violence, provided you check the corresponding boxes and describe those incidents on the form. If your situation does not involve violence, stalking, or threats of violence, but you still cannot afford the filing fee, you may qualify for a separate fee waiver based on income using Form FW001. Our guide on how to fill out Form FW001 covers that process. A court self-help center can help you determine which fee waiver option applies to your situation. After you file CH-100. Once you file CH-100, your case generally moves forward with two related forms. Form CH-109, Notice of Court Hearing, tells both parties the date, time, and location of the hearing. Form CH-110, Temporary Restraining Order, is the order a judge can sign to provide protection before the hearing, if the facts support it. Both the CH-100 request and any CH-110 temporary order must be personally served on the restrained person before the hearing, the same personal service requirement that applies in domestic violence cases. If granted after the hearing, a civil harassment restraining order can generally last up to 3 years and can potentially be renewed. You will also generally file Form CLETS 001, confidential CLETS information, alongside CH-100. Common mistakes to avoid. Filing CH-100 when the relationship actually qualifies for a domestic violence restraining order instead. Describing the harassment in vague or general terms instead of specific incidents, dates, and details. Forgetting to check the violence, stalking, or threat boxes when they apply, since they also waive the filing fee, leaving out household members who are also at risk from the same person, not requesting all the protections that actually apply to your situation. Generally, a shared child with the other person points to a domestic violence restraining order rather than a civil harassment one, since co-parents are one of the qualifying relationships for DV-100. If you're not sure which applies to your situation, a court self-help center can help you confirm before you file. If keeping track of all of this by hand feels like a lot, that is exactly what Virdix is built for. The wizard at Virdix.co walks you through these same questions in plain language and prepares your CH-100 for you. Virdix is a document preparation service, not a law firm. So this is not legal advice, but it can help make sure your paperwork is complete and consistent from the start.